Assalamualaikum warahmatullahi wabarakatuh to Madam Asnalisa. Today my group, which is Group 2, will be presenting about freedom of religion in Malaysia and based on the case Lina Joy versus Majlis Agama Islam Wilayah Persekutuan, and we will answering the question whether Malaysia is being an Islamic or secular state. My group consists of 6 people, which is SHAMIRA binti Muhammad SHAHRUL, NORINA binti AFFANDY, Atiqah Firzanah binti RASHIDI, ALIM bin ASSIR, IQMAL JOHANIS bin JEFRI, and lastly SHADIANA binti NOOR. Hi, Assalamualaikum. My name is NORINA binti AFFANDY and my match number is DIL211019. In this presentation, I will explain to you about the introduction. So let's get started. Azlina Jailani was born on 28 July 1964 in Malaysia to Muslim parents of Javanese descent. Lina Joy is a Malay convert from Islam to Christianity. She converted at the age of 26 and married a Catholic man. The Lina Joy case sparked a debate about apostasy in Malaysia and her failed legal attempt to not have her religion assigned as Islam on her identity card is considered a landmark case in Malaysia. Lina Joy's story is a striking example of what happened when the government rejects the idea individual conviction and choice play an important role in religious belief. Religion was the only thing that stood in the way of her acquiring her marriage certificate. The Civil Marriage Clause of the Law Reform Act of 1976 prevent Muslims from solemnizing or registering civil marriages. Despite her affirmative declaration that she was a Christian, she was denied civil marriage registration since her identity card lists her religion as a Muslim. Lina Joy's designation could not be revoked until she got a Sharia court decree saying that she was become an apostate, formally designating herself as someone who challenges God. Lina Joy pursued the case to civil court, but she was unsuccessful. Her application was denied, in part because Malay cannot renounce Islam because the Malaysian Constitution identifies any Malays as a Muslim by birth. The civil court ruled that she must first go to the Sharia court, but she declined, claiming that it is not for the court to justify her conscientious conviction. Despite multiple civil court challenges and legal help from the backup fund, the Federal Court of Malaysia eventually refused to acknowledge Lina Joy's conversion from Islam to Christianity in 2007. As a result, the state considered her marriage to be invalid. She was driven into hiding because she was frightened to create a family since any children she would be labeled as a Muslim by the state and could be taken away from her Christian mother on those grounds. Given that, the state would regard her marriage as null and void. Her children could be considered as proof of infidelity. Lastly, the Malaysian government's refusal to recognize Lina Joy's conversion violates the international law, which is the Universal Declaration of Human Rights, UDHR, and the International Covenant on Civil and Political Rights, Safeguard Freedom of Conscience, which is ICCPR. The rejection of the lower courts to hear this matter is also a deviation from the common notion that administrative law is controlled by co-constitutional rights in well-functioning constitutional democracies. I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is ALIM bin ASSIR. My metric number is DIL211018. Now I'm going to explain about the law in this case. First of all is the Federal Constitution. Based on Article 3 Clause 1, Religion of freedom. Islam is the religion of federation, but other religions may be practiced in peace and harmony in any part of the federation. Article 11, Clause 1 and Clause 4, freedom of religion. Every person has the right to profess and practice his religion and to subject to Clause 4 to propagate it. Clause 4, state law and in respect of federal territories of Kuala Lumpur, Labuan and Putrajaya, federal law may control or restrict the propagation of any religious doctrine or belief among persons professing the religion of Islam. Article 121, Clause 1A, Judicial Power of Federation. 1. There shall be 2 high courts of coordinate jurisdiction and status, namely A. One of the states of Malaya, which shall be known as the High Court in Malaya, and shall its principal registry at such place in the states of Malaya as the Yang di-Pertuan Agong. Lastly, judicial system in Malaysia. Malaysia has unified judicial system with all courts having jurisdiction over both federal and states legislation. The legal system is based on common law in the United Kingdom. The federal court is made up of the Chief Justice, the 2 Chief Justices of High Courts, and 7 additional judges. In this case, freedom of religion under Article 11 Clause 1 must be read with Article 3 Clause 1, which placed Islam in a special position as the main and dominant religion of Federation, with the Federation duty bound to protect, defend, and promote Islam. The special position of Islam in Article 3 Clause 1 is further reinforced by Article 74 Clause 2, which enable the federal and state government to enact Sharia laws to be implemented by a separate judicial system, namely the Sharia courts under Article 121 Clause 1A. To conclude, Article 11 Clause 1 gives a person the freedom to profess a religion of his choice, but the issue of conversion out of Islam of a Muslim, only Sharia court is competent to determine this matter.
Assalamualaikum, my name is SHAMIRA binti Muhammad SHAHRUL and my matric number is TIL 203902. I will present about the fact of the case. So, the fact of the case is the plaintiff was born as a Muslim. So did her parent. She was raised up by her Muslim parents and they practiced the religion of Islam. At the age applied to the National Registration Department (NRD) to change her name from Azina binti Jalani to Lina Lelani was the first attempt, then to Lina Joy. Reason for doing so were she had renounced Islam for Christianity and she intended to marry a Christian. However, her first application to change her name was rejected on 15 March 1997, but the plaintiff made another application to change her name and remove the word Islam from her new identity card. Again, her application without an order from Sharia court on the ground of her renouncement from the religion of Islam. The plaintiff sought for legal remedies in the High Court of Malaya.
Assalamualaikum and hi, my name is Mohamed Johanis bin JEFRI, DIL 211010, and today I will be talking about issue and help. For the issue is whether Malaysia being an Islamic or secular state. For help, court held that the case of Lina Joy had been held in Federal Court of Malaysia and her appeal was dismissed. The freedom of religion in Article 11 of Federal Constitution, but it does not mean that the plaintiff was given the freedom of choice to profess and practice the religion of her choice. In Article 11.1 of Federal Constitution does not provide that every person has the right to profess and practice his religion, but this provision must be read with Article 11/4 and Article 11/5 because the issue of change a person's, but this provision must be read with Article 11/4 and Article 11/5 because the issue of change a person's religion is directly connected to the rights and obligation of that person as a Muslim, and the issue of the conversion to other religion by a Muslim must be decided by law jurisdiction provided in Article 11/3A of the Federal Constitution.
Assalamualaikum, my name is Atiqah Firzanah binti Rashidi and my matric number is DIL 11002. Conclusion: whether Malaysia being an Islamic or secular state, I choose hybrid. My personal view is that Malaysia institutions are not theocratic religious governance, nor are they fully secular. In my opinion, Malaysia is being a hybrid state, which we can see that it is a combination of Islamic and also secular state. As we know, Malaysia using the civil law and also Sharia law. This shows that Malaysia recognized the main Sharia law, which is Akta Undang-Undang Keluarga Islam, Wilayah-Wilayah Persekutuan, 1984, Akta 303. Why do I say that Malaysia is not theocratic? Because Article 4 Clause 1 of the Federal Constitution states this constitution is the principal law of the Federation, and any law passed after Merdeka Day that is inconsistent with this constitution is invalid to the extent of such inconsistency. The issue on the position of Article 4 Clause 1 can be seen in the decision made by the Supreme Court in the case of Che Omar bin Cheso against the public prosecutor in 1988. Professor Emeritus Datuk Dr. Salim Faruqi, institutional expert, said that the institutional fellowship does not give any stipulation that Malaysia is an Islamic state or a fully secular state. Undeniable that in the Federal Constitution does not mention whether Malaysia is a secular or Islamic state. Commenting further, Shah said in the case, the decision of the Supreme Court, consisting of 5 panels of judges and head by the Chief Justice Tun Saleh Abbas, at the time ruled that the Constitution is the main law, while Islam is not the basic law in the country. So Article 4 Clause 1 is clearly the main law, and Article 3 Clause 1, which states that Islam is the religion of the Federation, should be read together with Article 3 Clause 4. In Article 3 Clause 4, it states that nothing in this reduces any other provision in this constitution, he explained. However, Shah said, to state Malaysia as a secular country, it is something that is not true, because all Muslims in Malaysia, who are also the majority of the people, are subject to Sharia law. But there are individuals who can be arrested for halwat because they are both in the same room and can be taken to the court to be fined or imprisoned. This is not the case in the secular country. Muslims are also obligated to comply with about 25 things that are under the Sharia law. So, we are a country that adopts plural laws, he said. Shah added, the debate on whether Malaysia is a secular country also depends on how one interprets the term secular. If secular means no religious values or doctrines imposed by the government on the people, then it is clear that we are not a secular country, because 61.5% of Malaysians who are Muslim are subject to Sharia law, he said. Meanwhile, Shah said he was of the view that the Federal Constitution already had a balanced element and was able to accommodate the diversity in the country while also analyzing the indigenous characteristic of the archipelago, the Malay majority, and the needs of non-Malays. The Constitution is a document that is already enough to achieve a just and equitable society. It is a question for how not only the judges, but also all Malaysians to interpret the document. It should be noted that 90% of conflicts that occur in the country do not end in the court, because it can happen either in government office, police stations, and schools. So, it is the responsibility of all, including government employees, police, teachers, and so on. If there is a teacher, for example, who is racist by telling his student of different religions to eat in the toilet during the fasting month, he is the Malaysian who does not follow the spirit of the Constitution, he said. Why we can say that Malaysia is not theocratic? Because our nation did not follow full Islamic law. We didn't use Al-Quran and Al-Sunnah as guidance for our nation's law. Article 12 Clause 2 rights in respect of education, which gives permission for the government to spend state money for the purpose of Islamic religious development, such as to Jabatan Kemajuan Islam Malaysia JAKIM, mosque and so on. For your information, Tun Dr. Mahathir Mohamad during the time of 929 declaration had stated and assured that the declaration of Malaysia as an Islamic state would not affect any changes in the national status quo and amendment to the constitution. Why we can say that Malaysia is a secular state? Because a secular state is one that does not confer any privilege or favor on any particular religion. In a secular state, no one gets punishment or there is no discrimination against people on the basis of religion he or she follow. Tunku Abdul Rahman Putra Al-Haj said that Malaysia should not be turned into an Islamic state because the country had a multiracial population with various beliefs. The nation was set up as a secular state with Islam as the official religion, and that this was enshrined in the constitution. Tun Hussein On also told reporters that he supported Tunku Abdul Rahman Putra Al-Haj's view. He also said that the nation can still be functioned as a secular state with Islam as its official religion. Besides that, apostate from Islam, living like a gay, and so on is legal in a secular state. If Malaysia is proposed to be a secular state, the government can't control Muslim anymore. If Muslim wants to go to the church, gambling and everything that related to the Lina Joy case must be approved, and it is also includes freedom of religion, freedom of choice and so on. If someone say that Malaysia is being an Islamic state because of Section 3 Clause 1, Islam Religion of Federation, it is clearly stated that Malaysia is an Islamic state. But if we see from the perspective from secular state, Section 3 Clause 1, Islam Religion of Federation, it is for official national purpose only. The late Tunku Abdul Rahman explained in the parliament session that this country is a secular country and the Islamic provisions in the federal constitution are only for the official national purpose.
Assalamualaikum, my name is Shadiana binti Sham. My metric number is DL203945. I will be the next presenter to talk about our comments of this Lina Joyce case. In my perspective, we need to amend the constitution and declare whether Malaysia is an Islamic, secular or hybrid so that it will be clear, because in federal constitution it does not mention what kind of institute Malaysia is. For example, Turkey and India clearly mention the word secular in their constitutional.